everyone, and welcome to our webinar on the Data Act. Today, we are discussing about the data economy of the future that we already know is here amongst us. So we wanted to discuss with you today with our wonderful line of speakers, what are the opportunities that this Data Act and the associated developments in the field of EU legislation are posing for companies, citizens, and the society as a whole. On behalf of Sitra, as one of the co-organizers of this webinar, we are very interested in this development as the Finnish Innovation Fund is looking at the future developments for a sustainable future. Sitra is an independent future fund, and our mission is to develop the successful Finland of tomorrow, and its vision is a fair, sustainable, and inspiring future that ensures people's well-being within the limits of the Earth's carrying capacity. Our vision is implemented by hundreds of projects that fall under Sitra's three themes: democracy and engagement, sustainability solutions, and the fair data economy. And in the latter theme, the fair data economy, we are building a human-driven fair data economy model based on European values as an alternative to a state-driven or data monopoly-driven data economy. This means that we promote changes in economic structures such as regulation and rules, and increase individuals' opportunities to influence the use of data, and we offer practical tools to companies operating in the data markets. And this all we do in close cooperation with our partners and stakeholders. We could not do this all alone, and hence we wanted to gather today a wonderful line of speakers to discuss the Data Act, that is the most recent proposals of the European Commission in relation to the European data strategy that is shaping the way for a fair data economy. Today we have a great line of speakers, and we will start with our co-organizers, Mia-Petra Kumpula-Natri's welcome words. Then we will move on to the keynote speech that will be given today by the Director General, Roberto Viola from the European Commission. Then we will hear from Francine Cunningham from Bird & Bird, who will be presenting a study that they did in collaboration with Sitra on the EU level data regulation. Then, reflecting these points of views that we have heard so far, we will hear commentary speeches in conversation with the citizens and SME perspectives with Marianne Terveen from Data Sovereignty Now Network and Luke Hendricks from SME United. Then we will move on to reflect some more with our MEPs who are here today to comment with us, Damien Boselager and Mia-Petra Kumpula-Natri. Lastly, we will close with the closing remarks from Project Director Laura Hallenius from Sitra. And dear participants, we encourage you to actively engage throughout this event in the chat. We wish that you keep yourselves muted and your camera off, turned off throughout the webinar. We, however, encourage you to actively participate in the chats by posing your questions and comments. And if you have any specific remarks, please address them specifically to the speaker you wish to comment or answer on them. And our speakers, we encourage you as well to engage in the chat with our wonderful audience. And although we cannot address each and every question during this event, we encourage you to participate in the chat because we will be returning to them after this event with our speakers. And of course, a note to make here, this event will be recorded and shared with you afterwards. But without further ado, I would like to pass the floor to Mia-Petra for your welcoming words for 2 minutes. Thank you.
So happy to have you, and Sitra, thank you for co-organizing this one and coming to the Brussels. The Data Act received by Parliament has not yet started in the officially working, as we know that many committees want to work on it, and we still have to settle the among the committees. But then I'm happy that in ITRE committee we will have sorted out who will work on the file. Unfortunately, the rapporteur Pilar de Castillo will not be able to participate today, but I will be shadowing, as well as Damian Boselager, who is at least online here. So the data strategy that also Parliament gave its INI report 2 years ago is now getting into flesh and meat, having the Data Governance Act already politically agreed, many platform regulation, AI going on, and now the very important puzzle and the piece in the puzzle, Data Act. We know that still about 80% of the European data is unused. Can we boost it with the Data Act, having more rules how to share the data with the trustworthy way, but also give rights and boost the access possibilities to make it in the business to business, to make it business to government, to also the public sector, to having the possibilities for the innovations. So it is wasted data that is not used, and that is what Europe can flourish more on, the data economy that is built on our principles and values. So huge potential to use data for the public sector to make it smarter and more efficient, but also the business cases. I feel this is the important moment to grasp in the Europe. So important afternoon for the Europe's journey towards data economy, and I expect great discussions. So I'm honored to pass the floor to Director General Robert Viola. Very happy that you are here, and we read that Commissioner Breton has a very good reason to be absent, as he's working on the digital cooperation with the friends from in America. Welcome, dear Robert.
Thank you very much, Mia Petra. Can you hear me and see me?
Yes, loud and clear.
Thank you. So it's really a pleasure, and thank you to Citra to have organized this event. It's a real pleasure to meet with you and introduce the newborn Data Act that completes, as Mia Petra was saying, what we wanted to do in terms of regulatory strategy under the data strategy, but also is part of the larger picture of providing fair and equitable rules for having a human-centered digital development in Europe. And of course, with the ambition to be a role model for the world. So we are completing our work when it comes to platform regulation. We, with the Data Governance Act, the Data Act, we want to deliver rules about data. Then we have in discussion our proposal on artificial intelligence. We want also to secure identity of the citizens and protected identity when they are online. That's our European identity proposal. And this really, I mean, it's completing what are the rights of users, of citizens, of companies when accessing online. So in this context, can I have the next slide, please? Let's see if it works. Yes, it works. So what is the reason why we should have a Data Act? Well, the reason is that we should be clear who can use data, what are the rights of the data users, what, I mean, the data user can ask counterparts, and also what and how to reap the benefits of digitizing industry, digitizing almost everything, Internet of Things, and make sure that everything that is connected, that generates data, ultimately is on the interest of the user. That's the reason why the Data Act is such an important piece of legislation that completes all the work we have done. The next slide, please. In this respect, the question could be, yeah, but I mean, there are so many legal acts that you have presented, completed, already in force. Why exactly the Data Act? Well, as I was saying before, because the Data Act looks at something which is very special and complements what we have done. First of all, clearly, you have two elements when looking at the data strategy and data regulation. One element is sharing the data, and the other one is owning the data. About the sharing model, governance model, you have the Data Governance Act, which has these three pillars: use as much as possible public data. Second pillar, allow the user to donate data if they want to do that. Third pillar, allow companies to share data with independent brokers. That really is, in a nutshell, the Data Governance Act. Then you have the Digital Market Act. And the Digital Market Act is about imbalance of power when dealing with large platforms, including having to use the data which are generated by those platforms. So it's a very specific case, it's a very special case that applies to the so-called gatekeeper platforms, the large one that will be subject to the obligation of the DMA. Then, of course, you have the horizontal and general data protection rules, which the Data Act does not change. Neither the Data Act intends to change the sectoral legislation, but progressively, a little bit like the AI Act, the sectoral legislation should follow the horizontal rules of the Data Act. So the Data Act comes in with the idea that we look at, how data can be shared in terms of who's the owner of the data, how the data ownership is transferred, how the relationships are forged. So that's why it has a very special role in the regulation of the digital economy, the Data Act. The next slide, please. Well, if we dig a little bit deeper into the Data Act, we see that there are a number of elements that are under this headline, owning the data and using the data to generate value. First of all, we would like to make sure that every connected object, every object which is part of the Internet of Things that generates data, can actually generate data in a way that users can reap the benefits. And of course, this applies to, electronic appliances, applies to connected cars, applies to industrial robots. We have not done one by one sector regulation, but we went for horizontal rules, a little bit the same as we have done for platforms. We have horizontal rule, the DSA, the DMA, we have done for artificial intelligence, and the same for the Data Act. So all the sectors which are part of the industrial internet, are part of data generation, will be falling under the Data Act. And also, we look at a special angle, which is the fairness of data contracts. In particular, when there's a relationship between big companies, small companies, we want to make sure that the SMEs have a fair deal when it comes to data sharing and data usage. We have seen too many times that larger companies tend to force conditions which are unfair, for instance, about the quality of data provided, about the rights if something goes wrong, and we want this to be redressed and addressed. We also would like to make sure that users can switch data provider. This is, a quintessential element if you want to have a well-functioning data market. So when it comes to cloud at large, so services which are about data curation, data storage, data computing, which are part of a large cloud offer, we would like that companies are free to switch, very much as is the case for telecom services. And of course, all of this needs technical standards, and interoperability as the underpinning element of this construction. Next slide, please. Now, if we zoom in about the user being confronted with a connected object, take, for instance, a car, take a fridge, take a robot, take an equipment used in agriculture. This is today, I mean, the situation. First of all, it's very unclear when purchasing a connected object, what are the user rights. It's very unclear whether there's full availability of data sets to choose an independent repair, for instance. So all the maintenance data which are necessary, all the telemetry data which are necessary about the object. Then, if it is an object where the user makes a business out of it, all the data sets which are linked with the user, are they part of the contract or are they not? So, frankly, very messy. What we hope after the approval of the Data Act will be a different situation. First of all, there will be clear contractual relationship between the user and the manufacturer. The user will be allowed to grant access to a third party, being it a repair outlet or, I mean, a business partner of the user. And in this way, you would have this kind of virtual triangle where, of course, also the manufacturer will be guaranteed that precious industrial property data is well protected. The safety and security of products are protected, but at the same time, have a clear understanding of what are the relationship and the rights of their customers. And so from the manufacturer perspective, from the user perspective, from the third party perspective, we are really striving to find the good balance. Next slide, please. So we went a little bit fast into a complex piece of legislation, but probably the ultimate question is the one that this slide addresses. So what exactly we aim for and what we think are the pluses if the Data Act were to be approved. And of course, we are great believer that co-legislator will enrich, will make it even better, as it happened with DSA and DMA and every legislation that goes through co-legislation. First of all, I said it over and over, we would like to unlock the potential of EU industrial data and create new and not imaginable possibilities today. One thing that, for instance, the Data Act does, it regulates, I think that's the first time in the world, smart contracts. So, for instance, if you have an industrial robot that executes a smart contract, a car, a charger that is approaching a charger that executes a smart contract, I mean, what are the elements of this smart contract and how the smart contract should look like? It's in the Data Act, which really will make Europe, I dare to say, one of the most advanced, if not the most advanced data economy when it comes to the element of smart contracts, and you combine with other things we have done, like, I mean, the legal use of credential on the blockchain, which is part of the EID proposal, then you have really, I mean, all the tools to really have very advanced data interaction, which are becoming part of the legal acquis. Protects the users, protect the SMEs, protect the users that when they buy a connected object or an object that generates data, they clearly know what they are buying. But also, as I said, it's important from the manufacturer point of view. We also, and I did not speak much about it, and I now use the final slide to do that. We are also looking at the relationship between government and businesses, what we call the government to businesses relationship. We have been regulated in what governments are giving out as data. They are called open data, and that's the Open Data Directive, which has been going through successive waves. Here in the Data Act, we look at the reverse, which is what are the obligations of business vis-a-vis the governments. And the Data Act provides clarity also in this respect by saying, look, I mean, normally speaking, there should not be any obligation by businesses, but in very special conditions to improve healthcare in case of a pandemic, in case we have emergencies, then businesses should cooperate with governments. And this should be done in a way, of course, once again, that the business prerogatives are respected. And then, as we discussed, a very important element is the freedom to choose the data provider when it comes to cloud, when it comes to all the services associated with the cloud. So that's in a nutshell the Data Act. We believe really is going to make a change. It's a rather unique piece of legislation in the world, and it really comes after 3 years of good preparation. And I here would like to thank the Finnish presidency of the Union, because they started this debate, I mean, with a series of reflections. Then all the presidencies that just arriving to the last one, that all organized debates, the parliament, the stakeholders that really participate in a very massive way to the public consultation we had. So here we are. We hope to attain those objectives, but of course now the Data Act is in the safe hands of the co-legislators, and we are really looking forward to work with them. Many thanks.
Thank you so much, Director General Roberto Viola, for starting us off for a wonderful conversation with our line of speakers to come. In the interest of time, we encourage everyone to participate in the conversation in chat and leave your comments and questions there. We will get back to them, and also encourage Roberto with his team to answer the questions if you have the time for that now. But next in the agenda, we will move on with Francine Cunningham from the law firm Bird & Bird, who will be taking it off from here about the Data Act and its relationship with the other data-related proposals coming from the European Commission. The floor is yours.
Good afternoon, everyone. I'm just getting my slides up here.
Looking good.
Okay, everyone can see that? Yes. Okay. Well, first of all, I'd like to thank our MEP host and, of course, Citra for organizing such a topical event today. And I can't think of a more topical subject we could be addressing this afternoon. I was very happy to have the opportunity to work with Citra on a recent study on the data economy and EU regulation. And there I worked alongside my Bird & Bird colleague, Tobias Rotigam, and his team in Helsinki to put together this piece of research. So I'll do a quick overview of the study. Just a moment, I'll make sure my slides are moving. Okay, I hope everyone can see the slides moving, yes. All right, so the Citra study examines the main data-related legislative proposals launched by the European Commission over the last 2 years, and we refer to them as the Big Five. Mr. Viola touched on some of them, but we will focus on the top 5 proposals. And I'll give you a very quick snapshot of each of the proposals. And everyone can see the slides, yes? Okay.
That's looking good.
Okay, so first out of the box, is the Data Governance Act. It will be the first of the big five to enter into force, and the purpose of the DGA is to establish a governance framework for reliable data intermediary services. It also aims to facilitate the reuse of public sector data. At the same time, the DGA is meant to promote what we call data altruism. This means companies or individuals could volunteer to make their data available, for example, by offering your health data to benefit medical research. Next up is the Digital Markets Act. The DMA is nothing short of groundbreaking, I would say. It will complement EU competition law by introducing ex-ante obligations for the largest online platforms, designated as gatekeepers. Now, gatekeepers are online platforms that offer core platform services. They're said to have an entrenched market position, benefit from strong network effects, and exercise market access control. As a result, both consumers and businesses are heavily reliant on these large players. New obligations for gatekeepers under the DMA will include measures regarding the use of data, data access by business users, and, for example, sellers using these online platforms will also have access to marketing and advertising data under the DMA. Then quickly turning to the Digital Services Act. While the DMA tackles only issues related to the very largest platforms called gatekeepers, the DSA will apply to a much wider range of services, such as online marketplaces, social networks, app stores, travel platforms, etc. There are also stricter obligations on very large platforms and very large search engines. So there's a kind of proportional approach. The proposal is based overall on the principle, what is illegal offline is illegal online. Its procedures include safeguarding against illegal products, services, and content online, as well as increasing transparency towards targeted advertising and recommender systems. And in terms of scope, the obligations under the DSA can be compared to the EU's historic decisions to introduce regulation of the financial services sector or the electronic communications sector. So it will really change the online environment hugely. Then next up is the AI Act, Artificial Intelligence Act. The proposed AI Act aims to ensure that AI systems placed on the EU internal market are used in a safe way and respect existing laws and fundamental rights in the EU. This Act takes a risk-based approach to AI, and it classifies AI from unacceptable risk and high risk to limited risk and minimal risk. Then finally, the main subject of today, the Data Act. I won't go into too much detail because Mr. Viola already gave an overview, but to recap very briefly, the proposal aims to facilitate access to and use of non-personal data, including business to business, business to consumer, and business to government. And small businesses in particular are set to benefit from the proposal's obligations on data holders to make their data available under fair, reasonable, and non-discriminatory terms, FRAN terms. And under the Data Act, the right of users to port data will be spelled out more clearly. And in addition, customers of data processing services, such as cloud computing, for example, will be able to switch service providers more easily. Then, if we just look very quickly at the timeline, this is a very simplified version, but as you will see, the big five proposals are at different stages in the legislative process in the EU, while the Data Governance Act is at the end of the process and will be enforced in more quickly than the others. The DMA and the DSA are on the brink of official adoption because both have reached political agreement, and the AI Act and the Data Act still have quite some distance to go. So there's still the possibility to influence and to give input on the AI Act and the Data Act. Then what will the Big Five mean for different sectors? The CITRA study looked at what the Big Five will mean for citizens, for the public sector, and also for business. So firstly, for citizens, well, an important change, of course, with the proposed Data Act is the right to data portability that allows citizens to obtain and reuse data generated by their connected products. That would be significant because consumers can then shop around and decide which service they want to go to in terms of after-sales service and maintenance. Also, when it comes to advertising, citizens will have more information about who is behind an ad and why that ad is being shown to them. They will also have the possibility to opt out of recommender systems. So those are quite significant changes for citizens. And under the Digital Services Act, they'll be able to report illegal content and products they come across online, or to challenge decisions where their own content has been blocked online. So some interesting developments from the citizens' perspective. Then turning to the public sector, what will the Big Five mean for the public sector? Well, when it comes to the Data Governance Act, this, of course, will facilitate public data sharing between the government and citizens and reuse of government data. And better access to this data should hopefully improve evidence-based decision-making in government. The incoming DGA will also trigger an obligation for public bodies to make data available to the private sector and to non-profit organizations. And then regarding AI, at the moment, not very many public bodies use AI when it comes to making very sensitive decisions, such as deciding about welfare payments or immigration decisions. And under the new AI Act, such systems would be regarded as high risk. So this could really raise the bar and set the bar higher when it comes to the potential use of AI by public bodies. And then finally, the impact on business, especially small and medium-sized businesses. When it comes to the impact of business, a lot of the people we interviewed for the study highlighted the importance of the DMA and also the DSA in leveling the playing field and providing more opportunities for smaller enterprises based on more fair market conditions. Data portability, like I mentioned, under the Data Act should also open up more after-sales services and new opportunities for smaller companies. And the very fact that the Data Act will also include measures outlawing unfair contractual terms and helping to prevent larger players imposing terms on a weaker party, that should also strengthen the position of SMEs. And overall, the Big Five can help to create an environment of trust, which of course will play an important role in promoting business. So one final piece of advice from us is that given the sheer complexity of the regulatory landscape emerging around data, big compliance efforts will be required on the part of business and public bodies. So what should you do? Well, our advice would be to start today, make priorities and start executing them. So anyway, that was a very quick summary of what is a 50-page study. So I hope that you will get the opportunity to go into more depths in the study. And of course, Citra is coming up with much more detailed recommendations as a result of this research as well. Thank you very much.
Thank you, Francine, for this presentation. Indeed, the study that Francine was now describing in 15 minutes will be published in English and in Finnish on the 7th of June. So keep an eye out, but more about that towards the end of this webinar. But for now, we will have a couple of minutes to ask questions for Francine. And just to start off with, Francine, so we're not just talking about, for example, in the case of the GDPR, that was a very fundamental move in data regulation. We're not talking about here only about one data regulation, but we're talking about indeed 5 of them. What is your point of view? What is Bird and Bird's point of view? Will these proposals result in greater legal complexity, and how we could facilitate the understanding about their benefits for society at large?
Yeah, well, a very, very good question. I think it's clear that the big 5 proposals are going to put a lot of stress on the compliance departments of companies, organizations, also public sector bodies. There's no doubt about that. Simply because of the overlaps between the proposals, and at the moment the lack of clarity about how all of these proposals will work together in reality. Because there's one thing, the theory, another thing is actually testing them in the real market, and that's when you will really see how they work. And at my office in Bird and Bird Brussels, I have the advantage of having literally a competition lawyer beside me on one side, an IP lawyer on the other side of me, and a data protection partner across the corridor. And it seems to us that you can't understand these 5 proposals from one distinct legal discipline. You really have to take a holistic view of the proposals to get to grips with them. So it is a challenge, definitely, not just for us, but also I think for businesses and for public administration.
There was a question, Francine, about the fairness and indeed about the unfair contract terms. And here we have a question that how can an SME initiate unfair contract term cases? It is a requirement to use applications, and in the US there is group litigation, which may gather several together, but one SME against a global company. Do you have views on this?
Mm-hmm. Well, that's a very valid question, but I understand that under the auspices of the Data Act, there is also going to be work done on model contracts, which should help SMEs in having a kind of fair set of contract terms that they can use. And all of that work on model contracts, on standardization, that's going to be vital. And that will really have a huge impact on whether or not this new legislation is in the end really effective.
Thank you. That is a great question. That was very nicely answered. There was a question regarding data replication or data sharing. What is your perspective on this? So we had a question coming from Robert. That was the overall picture, that will data be replicated or will data be shared, as in access granted to repository?
Okay, well that's very specific, and I'm going to give a very lawyer's answer, which it depends. It depends on the particular use case and the particular circumstances and the type of data involved, because data really can be protected under intellectual property rights. There could be data protection concerns involving the data. So it really depends on the type of data, the use case, the particular circumstances. But one thing which is sure is that quality of data is going to be an absolutely crucial issue in all of this. If you look at an AI system, for example, if your training data is not high quality, then your AI system cannot function correctly. So I think quality of data is going to be a burning issue in all the discussions over the Data Act.
Great, and that sort of would answer from your point of view also the question that we've had regarding artificial intelligence here and the quality of data. Mary asked here, do the quality of data or human in the loop cause the high risk of public AI?
That's another really interesting question. It's clear that throughout all of these instruments, the Commission seems to be very much highlighting the need for human oversight. And of course, you know, from a purely citizen's point of view, do I want an AI system deciding if I'm suitable to go on a particular education program, or to get a particular job, or to score my child's exam? I think from a citizen's point of view, we all want the reassurance of some human oversight, but of course humans are also fallible, and in some cases AI systems can be more efficient in some ways. So maybe the combination of AI plus an element of human oversight is basically the optimal situation.
Indeed. Thank you, Francine. At this point, before we let you go, I would like to ask you a final question about your point of view about what would you like to see for the next steps in this whole development of EU legislation and the regulation of the data economy? Where do you would like to see the development go?
Well, I think having that clarity about how the different instruments overlap and link up together is really really important. What I would like to see is having more uniformity in the terms and terminology used across the different proposals, because even something as basic as, you know, the DMA talks about gatekeepers, the DSA talks about flops, very large online platforms, and glosses, very large online services. There's even slightly different definitions of what data is. So I think having some sort of uniformity in the terminology used across the proposals would really help a lot.
Thank you so much, Francine, for your presentation on your study that Bird and Bird has done with Citra on EU data regulation. And thank you for taking the time to answer some of the questions.
Thank you. My pleasure.
Wonderful. And from here, I would like to request Marianne from Data Sovereignty Now and Luke Hendricks from SME United to take the floor. Great. Good to have you both here. First, a very brief question for both of you to reflect a little bit what we have heard so far. In just a minute, for both of you, starting with Marianne, what are your first impressions about what we have just heard about the Data Act and the big picture? In 1 minute, and then we move on with bigger.
Well, I think from a Data Sovereignty Now perspective, we very much welcome the Data Act. I think against I'd like to take it a bit broader. Against the backdrop of the current geopolitical situation, I think the issue of data sovereignty has become more topical than ever. And in addition to that, if you look at the recent developments in the US around with regards to the abortion rights, I think that the need to put fundamental regulations in place is imminent. So from that standpoint, we very much welcome the Data Act, and we actually are very happy that it marks the first time that data sovereignty is really put black and white in a regulation. So the fact that people and organizations should be in control over data they generate. So that's my first takeaway.
Thank you. And look, from your perspective, from the perspective of SMEs as well.
Yeah, thank you, Miriam. First of all, thank you for reaching out to SME United. First of all, we are extremely happy that the Commission has adopted this proposal, because we have advocated for it for many years, and it has cost us a lot of time and efforts to convince the Commission, and Mr. Viola will certainly confirm this, because there was also some skepticism in the Commission on our request for having a Data Act with the principles to ensure access to data for small and medium-sized enterprises. And it is an extremely important step towards a fairer relationship between smaller and bigger enterprises. And with this proposal, the Commission clearly shows that it had understood the needs of small and medium-sized enterprises in the data economy.
Thank you, Luc. So quite a positive response from both of you. And then I would like to pass the floor back to Marianne. What opportunities do you see coming from the Data Act? You already mentioned data sovereignty being strengthened, but where do you also see room for development? Where do you want to see this going forward?
Yeah, so I'd like to put from both sources. I'm working for a consultancy firm, Innovate, as a director data sharing, but today I'm engaging in this panel on behalf of Data Sovereignty Now. And Data Sovereignty Now is a campaign of like-minded organizations that believe that data sovereignty should be the guiding principle in the development of national and EU data sharing legislation. And as such, we see a few things that we deem important in the Data Act. As I said, we cheer to the fact that it's. We also believe that we should take it a step further. So we see that the Data Act is focusing on regulating data access in relation to devices connected to the internet or Internet of Things. And we believe the focus that seems to create a gap with data generated by users of other data processing service providers. So we think that the data generated by users of all kinds of digital resources and digital service providers should be put under the Data Act. And we see there, we would love to see it expanded in that direction. And then there's the point of, and I think, the previous speaker was making that point very imminent. Of course, it's seen as a compliance issue for a lot of organizations. But here we would also like to see the focus on innovation. So the second message is both for the Commission, but also for all organizations listening in. Please do see this as an opportunity for innovation and not just as a compliance issue. So of course, there's a lot to be done in terms of awareness here. So data is the new fabric of society, and we need a whole new way to deal with data. But we also like to ask the Commission in the implementation of the regulation to really focus on innovation. And urge to stipulate and guide the opportunities for innovation that it stands for. So if we look at examples of data sharing, for instance, the Data Sharing Coalition researches some of the use cases. And let me just use one example where people are allowed to share data from their energy meters to get green loans, to do something on their house to make it more sustainable, buy heat pumps or solar cells. And these cases still are sometimes difficult to make right propositions for those cases, business propositions. And also it still has some questions on the data of the energy meter. A rental house, who owns the data, who is actually the one who can use that data. So the second point is we have to focus on innovation. And the last one is that we say we have to get interoperability right. So to support really the adoption of this Data Act, it will require some form of soft infrastructure for decentralized data sharing. And in that, we strongly believe in the constructive position of the Data Innovation Board with the Data Sharing Support Center as maybe its executive branch to really focus on getting this interoperability right. And I think Mr. Viola also opened up. I mean, this is a horizontal regulation, but we need to get also in the sector specific things, we need to get interoperability right. So that is what I would like to add here.
Thank you, Marianne, for a very concise and nicely structured input on the opportunities and the improvement points that you see for the Data Act. How did this sound for you, Luc? From your perspective, are the points of opportunities and the way forward similar? Or how do you see the road ahead?
Well, Mary, I would certainly not contradict Marianne on. Okay, I thought I was muted. Sorry, I will repeat. I will certainly not contradict Marianne. I fully agree with what she had said. And you asked the question about opportunities. Of course, this is always very, I would say, sexy when there is a new legislation. But for a lot of SMEs, it's not only about opportunities that this new legislation will offer, but it will simply allow them to continue their activities. And especially this is the case in the aftermarket services, which is the case. And already in a lot of examples, there is reference to the repair sector in the car sector, but also there, this legislation is setting out some principles, but especially for the automotive sector, we will need a more specific sectorial legislation, and we are also happy that the Commission is already preparing this. That's the first thing. On the other hand, and Mr. Viola also mentioned it, and there also we fully support this. It is, of course, an opportunity for the aftermarket services, and it's also complementary to other initiatives of the European Union at the moment, as the Green Deal, or for example, also on the digitalization. Marianne made a reference already to the energy consumption. Nowadays, a lot of the tools and machineries that our SMEs are using do not allow to have the data, especially concerning, for example, the energy consumption or the data that they can retrieve from their machineries can be helpful in in, for example, in saving the use of materials like energy, water, and so on. So there it will certainly help. And this is also in line. As you know, there is the proposal of the Commission concerning corporate sustainable reporting directive. So therefore, the SMEs and companies in general will have the obligation to report on certain issues like, for example, energy consumption. So this Data Act is extremely important also in the future in order to enable them to fulfill their legal obligations. And also, for example, and there we had a lot of consultations with our members, because as I said in the beginning, we had to convince the Commission with hard data on the need for such a Data Act. But for example, also in order to, for example, for in certain sectors, you need, I will give the example of the textile cleaning industry. You need there some procedures, but the actual situation does not allow to control these procedures. And this is only possible if the companies, if the SMEs have access to the data. Mia Petra also mentioned in the beginning that 80% of the data are not used. And this is also revealing another important point, that a lot of our SMEs are not aware of the possibilities of data. So there, and this is of course not part of the Data Act, but it is more an accompanying measure that we really need, is that we will need more training and awareness training amongst SMEs, but also about capacity building in SME organization on the importance of data and data sharing.
Thank you so much, Luc. That was a great insight into your perspectives on the Data Act and the development within the data regulation. Before we hand the floor to our MEPs to comment on what we have heard so far, I would like to request Marianne and Luc, you to give, again, in 1 minute, your key takeaways for legislators to ponder on this topic. And Marianne, if you'd like to start.
Well, I think, and it's not just for the MEPs, but also to all other people are listening. I think data sovereignty should be as important as CO2 reduction. So for now, it's as also Luc pointed out, it takes a lot of awareness. So if we go backwards 20 years, there was not a lot of action perspective if you wanted to do green. And now there is. We've come a long way. And I think it's the same way with data sovereignty. It should be the guiding principle, the polar light. So in order for regulation, but also in order to make your business thrive and make it digital sustainable. So look at what can you do? How can you valorize data and make sure that you offer your customers data sovereignty? And I think the Data Act opens up a great way to do so. And, or I will not use the word but I still think that the Data Act is a great way to add means to the rights that were given to us. So it's a quote from Vestager herself, who says, the GDPR gave us rights, but no means to exercise those rights. And I think the Data Act is doing that. And I think in order to really create the landslide that GDPR created, it would be beneficial to look at that, to how we can expand the Data Act to not just cover IoT devices.
Thank you. And then Luc, your key souvenir in less than a minute.
I will be very short, Mary. We have only one request to the European Parliament and to the co-legislator, and that is, do not water down this proposal. There will be a lot of opposition to it, but do not water it down, and ensure that this proposal is still adopted during this term. And we are to your disposal to improve the Data Act. It's not to criticize it, but I think that also concerning, for example, the scope, that there can be some improvements, but do not water it down.
Hear, hear.
Thank you so much, Marianne, for the souvenirs, and we are ready to move on with our program to discuss these topics further. And next, I would like to welcome MEP Damien Vorselager to hear his impressions on this topic. So what are your impressions on the points that we have heard so far? We have gotten the big picture about the Data Act and the regulatory tsunami that is going on currently in the data economy in the European Union. We had some perspectives from SME Europe and SME United and Data Sovereignty Now. So we would like to hear your impressions on this.
Yeah, I think a lot of very interesting points were made. So I'll try to really pick out one specific part of the Data Act, which is, as was pointed out by the lawyer from Bird & Bird, obviously part of the big five. Yeah? So I'm zooming into the last one, if you want, and I'm zooming within that Data Act to the question of data sharing, which also was, I think, the biggest part of the previous discussion, and which for me is also a centerpiece of the Data Act as a whole. I mean, maybe just like a super word on background because of my background, because it explains a bit my perspective. So I founded a political movement, and then we tried to basically across the European continent run for European elections. And the reason why I say this is because my perspective is that of the startup, a political startup in this case, entering into a rather oligopolistic market structure, if you like. And this is also the view that I have on the data economy. I would like to make sure that there are competitive markets that allow for innovation and that really, are open and don't have high barriers to entry for new entrants to come in. And I think if you look at the current, I don't think so. If you look at the current data economy, what we have currently in the data storage space is already, a very concentrated market. It doesn't mean that these data cloud service providers have, full access to the data they're storing, but it is a very concentrated market. And which is why, for me, when we negotiated the Data Governance Act, which was also mentioned, it was super important to ensure that the data intermediaries that we regulate in this context are neutral and cannot be bundled together with other services, such as like the data storage. And I mean, now the Data Act comes after that and somehow needs to ensure that there's actually enough data to be traded on these data intermediaries or data stock exchanges, which we regulated as being neutral intermediaries. And that's when the Data Act comes in. And if you then look at how, connected devices are currently being designed, but I think also in many other areas where data is currently shared, you have the issue that the operator, and that the operator is often the manufacturer, has almost exclusive rights when it comes to, let's say, de facto judicial control when it comes to the data that is being produced by these devices. And that's interesting because, someone often, or like in most cases, buys these devices or leases them, but they don't have the actual control over them in many cases. It's not always the case. So, but if you have that, the problems come out of it. First, how easy is it really for the person who actually owns the device to switch the operator of that device? And I think that is at least partially addressed, and I will come to this in the Data Act. But there's also a question of what rights in terms of sharing, and here I want to also make one specific sharing point very clear, of monetizing this data. So if you connect it back to the Data Governance Act, what right do I have as an owner of that device to put the data that I'm co-producing on to a data intermediary, a data stock exchange, to sell it? Why is that so important? It is important to really unlock this data that we're currently talking about. So you should have two rights. You should have somehow the right to switch the operator if that's technically feasible. And you should also have the right to monetize the data so that you can have this unlocked potential that we're currently talking about of new business models establishing themselves based on the data that is out there if they somehow convince, the purchaser or the user of a connected device to actually share that data with them. And that's the perspective I'm having. And if you look with this perspective onto the Data Act, you can see that there is a step in the right direction. Yeah? So we partly achieve this goal by allowing the user to request that his data or her data is being shared with a third party, and this has been also mentioned by Mr. Viola. But it somehow assumes this idea that the manufacturer or the operator is the data holder, and that he or she, that the company is really the gatekeeper that can then, you know, transfer this data to another company. And with this, and after having had a lot of discussions with experts about this, that is a strong assumption that basically pre-builds a certain kind of business model. And here, I think we really need to look into it, because I don't believe it really creates the best incentive for users to share the data and potentially also, you know, benefit from the data they're generating. And it really produces, or like puts the producer in this pole position and like really at the center of the whole data economy. And I'm not sure that this is really then going to get to the aim of, you know, reducing barriers of entry and actually unlocking the potential of the data economy. So I think when we will consider, obviously, for some more time, the amendments that we will put forward, but I think I will go in the direction of trying to ensure that it is really the consumer or like the owner of such a connected device who is in this kind of gatekeeper position, if you have to have one, and not the manufacturer, to be able to actually then trade the data in the marketplaces. And obviously, I do believe that manufacturers should have a certain right to access to the data so that they can improve the services that they're providing if they're operating these devices. But because they're obviously connected, which means that there's a constant update possible, and there should be also the operation running and like an improvement running. But how much more can be done with that, I think, is an interesting question. There are many other elements, and then I'll stop because I think you know, there's a lot to be said. But just a couple of points. I think when it comes to the B2C and B2B differentiation, we can still do something. I think I heard what you said about the scope. I think there's a lot that can be done. And there's a range of other stuff that I will not mention now to give the others also some more time. But I think it will be a very interesting and very crucial discussion for the data economy. And maybe as a last point, I do think that this is not only potentially making GDPR operational, I do think it could basically manifest a certain GDPR impact, like impact, if you want, in industrial data. Thank you very much.
Thank you so much, Damien. And it is indeed a big challenge to fit in everything within a couple of minutes of time. But do stay along, and we have some further questions, and hope that you can answer also in the chat about the conversation that is going on in there. But at this point, I would like to pass the floor to our co-organizer, MEP Mia-Petra Kumpula-Natri, and to hear your impressions now in turn. What are your thoughts so far about the conversations we have had?
Yes, thank you very much. I enjoy very much the speeches and the comments of the panel and the keynote speakers, but also I try to follow the very, very good questions of the chat, and I already thank Sitra that you promised to take all these questions from the chat, that we could also have them because they are going really deep into the articles and then what the general purpose for this whole regulation is. So very, very good questions, but I'm happy this is only the beginning of our path towards the final legislation. As Damien mentioned, we are not even on the phasing the deadlines for amendments now, so we do have time also to do it. For SME United, yes, I promise not to moderate down the importance that we can do that, and they take this opportunity to get more players with more innovation or more data usage ideas for better services. And what I picked up from the hints that Birds and Birds give, that start now, nominate a responsible data person is something that I also heard last week in a panel, and I think it's very important idea that many organizations have someone who will kind of sit on the data, the possibilities, but also the seeing the whole policy and hopefully unleash the potential, and then maybe finding out new ways to use the data or donate it or trade it or give it out for the governance structure that we also will create on the DGA. So that is one very, very important hint that we do have a person there as Luke asked for the capacity building. Maybe have a capacity building and start with the responsible person on data. But I think this focus very much on the business to client or the B2C and puts user to the focus even in my data spirit, which I like very much. And then again, that the user can sit on it. We have tried to elaborate the idea on the rights, that who has a right to control, who has right to access, and who has right to use the data. So this also there was a question on this multiple data rights on the same asset, and the answer nicely from Commission that it remains a challenge. So then if we clearly, as also Birds and Birds hinted us, use clear terminology, so we should have also clear picture of the different rights that we pose on the data at the same time when we try to create more usage and clarity. And this clarity would then make this society easier to invest and come on board as an innovator, the new public services or business cases. So let me have my third comment on the business to government side. At the moment, I'm still studying it, reading it more, but I do feel a bit disappointed that the whole chapter 5 about the public sector is about the exceptional needs, because I think this is also the way to make the society that we saw. It is about societies, and when we need information data for the pandemic, but then when we need it for the everyday health. So it's not exceptional when you have everyday health or everyday improvement of the traffic or everyday updated information for the political decisions. So my subject that I do love is the real-time data for the decision making. So that can be elaborate, I think, a little bit more, that how exceptional should be the exceptional, so that you can develop your government data. It is the public services. So that was something that I will really have to read again. That if real-time data cities, is it the green, digital, or well-being of the citizens? I think we have to take care of that every day, not only exceptionally. And this is a lost opportunity if we make it only possible when it is an exceptional case in our minds. Actually, I can recall here the European Parliament resolution on data strategy that I happen to be the rapporteur, and we call there, now I quote, calls Commission to further define business to government data sharing circumstances, conditions and intensives under which the private sector should be obliged to share data with the public sector, such as due its necessity for the organization of the data-driven public services. Yes, then of course the first measure situations and so, but I think it's important to find the right balance between interest of companies in getting fair remuneration for the data, collective interest in making the data useful for themselves and for the societies. So I do not want to put the threshold too low, but put it very high so that we can steer the societies and future we want business opportunities, but also better functioning societies. Thank you so much for all the ideas and the very difficult questions as well. Some of them are not easy to answer, but I try not to be the engineer from educated too long ago and not to be able to understand. But the political picture is there, that interoperability, good governance for the data, values we want to bring in can take us further. And this is the motivation for the Data Act.
Thank you so much, Mia-Petra, for your insights and comments on the conversation so far. As you nicely recapped, it has been a lively conversation also in the chat. And indeed, we will be gathering the comments and questions, and we will be getting back to them as good as we can and moving forward with them for the Commission as well. At this point, I would like to request Damien also to maybe, and also Mia-Petra after that, to give also 1 minute takeaways from this conversation. So just to sum up, what would you like the participants of this webinar to take away with them home and to really think about this Data Act? What will be the key takeaway from your perspective, reflecting on these conversations? Damien, go ahead.
Maybe I can start.
Maybe you could start, indeed. Go ahead, Mia-Petra.
Yes. So what I see from the questions, it is difficult and still clarification is needed. And so maybe also the Bird and Bird report will guide us, but then all, for the big five, the legislative package. But what I wish that we can do here is also to unite the governance so that there is not very many different terminology was good example, but also the bodies and then responsible like knots in the society, because we created already data innovation board for the DGA for the those data sharing ways, and then also we have the data spaces, but then we have the national regulators, the contact points in the Commission. So all this governance also should be as clear as possible so that we can really take the way, so that the idea of having more participants, it means more SMEs, and SMEs normally do not have that much big departments for legislation and for the liabilities and all that should be as clear as possible. So at least the governance should be very, very clear and good, and we have to look at it as this is now the fifth, the last 5 in the big 5, that we do not innovate too much new stuff, but rely on the created structures, because for the companies, they do not have 5 pieces of legislation, they have 1 company, and that should then manage in a new data economy that we are creating.
Thank you so much, Mia-Petra, for this souvenir. Do we have Damien on the line to give last calls to action? If not, I would like to give the opportunity to give the last.
I'm here, yes.
You're here, wonderful. Then go ahead. Last call.
No, I mean, I was going a bit through the questions. I mean, there are a lot of them. I see that some people do agree with the idea of like potentially giving users a bit more control. I see that there are a lot of questions about, the switching. I think it's difficult to answer all of them. So I'm happy that Mr. Viola's team said that they would be willing to go into this. But I think, from my perspective, I think both Mia-Petra and myself, we are very open to hear your thoughts and questions and to discuss further. And I would be very happy to also talk about the other elements of the regulation, because I just focus on one. So I'm very happy to see this as the beginning of the conversation.
Thank you so much for the both of you for your great insights and your cooperation in also looking through the questions and answering them also after this webinar potentially. Thank you. So at this point, we're ready to move on to the end of this webinar. And indeed, as Mia-Petra also mentioned, this is just the start of the road. We will be moving forward from here in tight collaboration with all of you and other stakeholders here in Finland and the rest of the European Union as well. But more on that, I will pass the floor to my colleague, Laura Hallenius, the project director from Sitra.
Thank you, Mary. It has been a true pleasure to follow the insightful keynotes and discussions. On behalf of Sitra, I want to thank you all for your active participation. And this is just the beginning of this conversation. Sitra is Finland's future fund. As we see it, data is the most important raw material of our time. The Fair Data Economy is one of Sitra's 3 themes that we believe will most change society in the future. We see that the Data Act is step to right direction. One thing that has become clear in today's conversations and insightful keynotes is that whether we can make data a competitive factor for Europe depends on all of us, entrepreneurs, legislators, researchers, consumers, and individuals. It depends on the rules of the game, where regulation is just one piece of the puzzle. And we still have a lot to do. Therefore, I would like to end with a call for action. Take part in the dialogue about the fair use of data and the Data Act, and promote it for benefit for us all. We at Sitra will also continue facilitating this dialogue. For our Finnish-speaking friends, we are organizing a stakeholder event on the 7th of June, where we are focusing on the impact that the Big Five regulation have for Finnish society and how we can make the most of the opportunities offered by this regulation. Please register at the sitra.fi, and you can also find the link in the chat. Finally, I would like to welcome all of you to Helsinki next month. We are proud partners of My Data Conference, which takes place between 21st and 22nd of June. So I hope to see you all soon in Helsinki, and I already know that Mia Petra will be there. But for now, thank you once again, and goodbye.